Good afternoon. Today is December 2nd, 2021. This is the Board on Professional Responsibility. We are convened in the matter of Dana A. Paul, Board Docket Number 19BD63 and Disciplinary Docket Number 2019 D11199. Will the parties please identify themselves for the record, and I will start with Disciplinary Counsel.
Hamilton Fox for the Office of Disciplinary Counsel.
Thank you, Mr. Fox. Respondent.
Dana Paul.
Good afternoon, Mr. Paul. So just a couple of preliminary things before we start with the argument. We are in a virtual courtroom, and I suspect after all of these months, many of us are familiar with this, but it never hurts to remind everyone to remain on mute when you are not talking. For the party arguing, you may remain off mute while you're at the virtual podium, but then when the other side is arguing, please be on mute. The board members will be interrupting with questions, and I recognize that can be difficult on Zoom because it's hard to hear two people talking at the same time. So board members may, if they're having difficulty jumping in, kind of give a visual cue of a hand wave or something like that. And so just sort of be aware of that, because we do want to make sure that all the questions are addressed. And if needed, I will play traffic cop. I also want to remind the parties that in this case, there are some confidentiality issues. The hearing committee handled that by referring to initials for the former client. And I will just remind the parties to please maintain confidentiality and please continue to use the initials as needed. Assuming there is no other preliminary matters, we're here on exceptions to the hearing committee report from Mr. Paul. And so Mr. Paul, you will proceed. You have 20 minutes. Would you like to reserve some of that for rebuttal?
Yes, I am going to submit on my pleadings. Thank you for your time, Your Honor. So thank you for your time first. I'm going to submit on my pleadings and just briefly add 2 notes and then save the rest for rebuttal, if that's okay.
Okay.
All right, first, I'd like to say the petitioner makes a big deal about John Doe having to hire an attorney to defend herself for this grievance. Let's be clear. I filed the grievance because John Doe unlawfully taped my phone calls. That's a misdemeanor, Maryland. That's prohibited conduct. There's nothing illegitimate about that grievance. So she would have had to hire a lawyer in any circumstance. Number 2, the hearing commissioner didn't.
Mr. Paul, are you saying that if you had not filed the disciplinary complaint against John Doe, that you would have filed a criminal complaint or a civil complaint based on recording your phone calls?
No, I argue that her taping my phone calls is an action prohibited by the disciplinary rules, and it's not protected by attorney-client privilege. That's not attorney-client privilege when the client tapes your phone calls.
What's the basis for that argument?
What's the basis that's not attorney-client privilege? How could it be? There's no legal advice in there. She has no right to take my phone calls in Maryland. I realize that's okay in DC, but that's not all right in Maryland. And this is where all this occurred.
So it's my understanding, Mr. Paul, that in the factual record reflects that at some point, your former client, when she was a client, provided you with a transcript of a recorded call to find out if it's something that could have been used as in her underlying case. So that would have been seeking attorney information and advice. Is that right?
Yes, but that's a different disclosure. Her taping my phone calls is not the same as what I submitted. Okay, Your Honors.
Okay.
Even if let me interrupt here, Mr. Paul. The rule goes not just to attorney-client privilege information, but it also goes to client secrets, correct? And you may not think it's a worthy secret, but And I'm not saying one way or the other, but it was a client secret one nonetheless, wasn't it?
It was a secret that she taped other people's phone calls. It was not a secret that she taped mine. There's no attorney-client privilege for taping my calls. There's no legal advice given. There's no trade secret or client secret involved. She committed an unlawful act. That's
Wait,
prohibited by the disciplinary rules.
Go ahead.
No, you go ahead. No, you go ahead, Mr. Walker.
I mean, doesn't the notion of a client secret get to information that the client might find embarrassing? It's a fairly broad category, isn't it? And there's a fairly clear and strong duty to a client to maintain secrets, whether or not they are actual confidences or fall within the attorney-client privilege.
Not when it concerns an unlawful act committed against the attorney, Your Honor.
Mr.
There's no
Paul,
secret there. She's not protected to commit a crime against me. There's no secret that involved. There's no rule that gives her that right to do that. She doesn't get the right to break the law and then say, oh, it was an attorney-client privilege, when I'm not involved in that decision. She did that on her own.
Mr. Paul, so are you suggesting that if you're representing a client and that client hypothetically has a thumb drive with information on it that may be under subpoena by the government or by opposing party, and they tell you, I've thrown that hard drive into the Potomac River, are you saying as an attorney, you are A-okay to go file a complaint with government authorities and say, my client just threw a piece of evidence into the Potomac?
That's a different hypothetical.
Explain to me.
I'm only concerned about the fact pattern we have here. I'm not an expert. Can't answer everything, but that's a different fact pattern. That's a destruction of evidence about something that already occurred. I complained about something that occurred that it concerned me, that she had no right to do. It's an unlawful act.
So, Mr. Paul, I have two questions.
Let me ask, you're saying here that you filed your complaint because your former client did X. Haven't you previously indicated that you filed the complaint because a complaint was filed against you? So is what you're saying here consistent with what you've previously stated on the record in this matter?
Well, I believe people can have more than one reason for acting. I could file that complaint. She filed that grievance against me, I believe it was in April. I didn't file my counter complaint until August. I believe a lot happened in that time. I had no intention of filing the complaint against her for tapping my phone calls, even though it was prohibited, because I didn't want anything to do with this woman. She's over litigious. But a lot happened after that. She filed frivolous contempt motions against me, against the other attorneys, saying we collaborated, against innocent witnesses who had to get lawyers who contacted me and told me this. And then she filed grievances against both me and the other attorney that were dismissed. And we had a hearing before the peer review, which is equivalent of what we're having right now in Maryland. And I had to disclose these same things I'm disclosing to you as part of my defense, which they ruled was part of my defense, that because one of the things she argued was that I failed to stop communicating with her. Well, I stopped communicating with her because she was taping my phone calls. That's why I stopped communicating.
Mr. Paul, let me
Okay,
ask you, I do appreciate that you filed, a complaint was filed against you by your client or your former client, and that you responded to disciplinary counsel. You then, after you did your response, filed a complaint against your former client. So let me begin with, is there information in the complaint about your client that differs from the response you gave to ODC?
Can you repeat that question?
Sure. As I hear you, you're saying the complaint you filed against your client was necessary to defend against the complaint she filed against you.
Correct.
So my question is, was there any information in the complaint that you filed against her that differed? Maybe it was more information than what you had already provided to ODC as a response.
In my initial response?
Yeah.
Basically,
what I'm asking you is, if it was your defense, why didn't you include it in your response to ODC?
In my initial response, I didn't include any kind of opposition because I don't believe ODC had the authority, the jurisdiction to initiate these contacts because all the conduct occurred in Maryland.
So
Maryland
did
is,
you give them
Maryland-
a response later?
yes, I created my response later. I
Right, so
said that-
Mr. Paul, I just want to make, you said that about the jurisdiction more than once. That's rejected. That's just not a thing. The DC Bar Council had jurisdiction over you. So in your answer, the question that you're being asked here, to make it clear, you defended against the complaint filed by John Doe against you in DC with Office of Disciplinary Counsel, correct? And
Yes,
then, okay, and then you yourself filed a complaint against John Doe.
correct.
The question is, was there information that you used to defend yourself that was not included in your complaint, or was there information in your complaint that you did not use to defend yourself? That's the question.
My answer was, as I said, I didn't defend myself in that complaint because I asserted a jurisdictional argument. I never defended myself until this petition was filed against me. I take that back. I defended myself in several letters to them, and I alleged the same thing. She was taping my phone calls. Now, I did include some more information. Granted, I will give you that. I did include some more information because in the Maryland peer review, it came out, well, how do you know she was taping your calls? And I told them, well, because I've done enough telephone depositions, that I know how my deposition is being taken. And also because she
Paul,
told
I'm
me
going to
this.
interrupt you. I'm going to interrupt you for a minute because you did start by saying that you only wanted to make a couple of points and then save time for
Well,
rebuttal.
I'm answering questions.
I know. I totally, I'm not faulting you on that, but I do feel like perhaps we missed the point that you were trying to make at the beginning. And so I want to clarify, are you arguing that the information that was in the complaint about NE isn't client confidences or secrets?
Some of it is, but some of it is related to my defense and my belief.
Okay,
I
so
believe-
let's talk, so you started with stuff that you thought was not a client confidence or secret. So, but you're acknowledging that there was some. So let's focus on the stuff that is a client confidence or secret that was included in the complaint.
Yes.
Why is my understanding, your exceptions is that is not a violation, however, of 1.6. Can you explain why it's not a violation of 1.6 to have included client confidence or secrets in a complaint?
Because it was
about NE?
necessary for my defense. In the Maryland peer review, which I said it's the same as this, they asked me, how do you know that? I said, I know just for the same reasons I stated. I've had enough telephone depositions that I know when my deposition is being taken. And she already told me she was taping people's phone calls. So I knew she was taping my calls. So I believe that was a necessary part of my defense. And then in my next letter, just to jump ahead of you, in my next letter, which I repeated some other things, which are not related to her illegally tapping my phone calls. And let's not mince words. It was illegal. I believe I presented that because she attacked my credibility. She denied all this and said, no, Mr. Paul's lying. So I presented these other examples of when she had lied, which if I beg to argue, I don't believe that she has a right to commit a fraudulent forgery and submit a settlement agreement without telling me under my name, and that's protected. I don't believe that's protected when the other attorney discovers that and threatens to file a grievance against me. I don't think that's protected conduct.
Okay, so I just want to make sure I understand your argument. You're saying that under Rule 1.6E, you were allowed to make and reveal client confidences to the extent reasonably necessary to establish a defense to a disciplinary charge.
That's yes.
And so we would be able to then look at the complaint about you and trace directly to the complaint you made about NE, how it defended against your charge?
Yes.
Okay.
In my reasonable belief, and it has to be a reasonable belief. I don't believe I'm being unreasonable. I don't.
Any further questions, or should we reserve the rest for rebuttal?
Well, yes, one last things that go to your thing.
Can I just point out one thing?
Yes,
If perhaps you shouldn't be specific about what it is that you're alleging was done by your former client. I think you want to hew to that line of keeping confidential what is supposed to be maintained as confidential in these proceedings.
You are correct, Your Honor. I apologize. I'm just, feel like I'm in the shotgun here. I wanted to say just, and this goes to what we've just been talking about. All the reasons for my filing a grievance are corroborated by other evidence. There's independent evidence that she filed contempt motions. There's independent evidence that she filed grievances which were dismissed. There's independent evidence that I submitted this stuff before the peer review panel. That's all backed up by independent evidence. And instead, the hearing commission disregarded all that evidence and relied on these one things which said, well, I'm only filing this grievance because in retaliation. Well, in that same paragraph, I explained why, because she's already filed. I mean, I'm stuck in this case. I believe they disregarded the majority of the evidence. I don't believe that passes the clear and convincing test. And lastly, real briefly, this is my biggest argument. I don't know how much you're accepting it or not, but let me add a rule about statutory information. I'm sorry for blocking the view. Statutory interpretation. It's called the literal rule. It's the first rule of statutory literal interpretation. If the rule is literal and there's nothing ambiguous, then there's nothing to interpret. You give the rule the literal meaning. And the Spikes Court has already held that absolutely privilege is not ambiguous. There's absolute immunity from my filing this grievance. And it's confidential because I only filed to the petitioner.
So,
The
Mr.
second
Paul,
rule, yes,
yeah,
I'm sorry.
no, I appreciate the plain language argument you're making. I just want to clarify that now differs. We're not talking about Rule 1.6 anymore. We're now talking about
Rule 19.
Section 19 of Rule 11.
Right.
Okay, and so that's an alternative argument that if in fact this information was a client confidence or secret, it still would protect you under this absolute immunity or absolute privilege. Is that?
Yes, thank you for making that.
I just want to make sure. I just want to clarify to make sure I understand your argument, and then
Yes,
I will let you go from there.
Yes, thank you for clarifying. The second rule of statutory interpretation, in which I believe rebuts the petitioner's main argument against my interpretation, is the rule of inconsistency. The petitioner says that my interpretation would make inconsistent rulings. What's called the rule of generality. If there are two rules and one is more specific than the other, it's the more specific rule controls unless it is the intent for the more general rule to govern. I don't think there's any argument that the rules propagated by this board were meant to govern the enforcement of the disciplinary rules. And I believe the rule of generality mandates that my interpretation of absolute privilege is the controlling law. Thank you for your time.
Thank you. We'll give you time on rebuttal. Mr. Fox, once the clock gets to 20 minutes, you may begin.
For some reason I can't see the clock, but
Oh, okay. Well, then I'll let you know.
I don't think I'm going to need 20 minutes.
You may begin.
Mr. Fox, I think out of the box, can you address this point that petitioner made or respondent made, I'm sorry, about statutory interpretation, that a literal and plain rule does not require interpretation, and the phrase absolute immunity as it goes to the filing of discipline complaints, Rule 11, Section 19A. Can you tell us, walk us through and tell us why absolute immunity doesn't mean absolute immunity?
Well, I think the question to that, the response to that is absolute immunity to what? And I think, and frankly, I don't know if I can approve on what the hearing committee said, but that in context, what the Rule 11 is talking about is absolute immunity to a civil suit, or perhaps, I don't know, there might be some kind of administrative proceeding or something. But the second sentence of Section 19, which deals with the constituents to the disciplinary system, specifically says that those folks are not only immune from civil suit, but in addition to that, they cannot be, that disciplinary proceedings cannot be brought against them for their conduct. I think it's probably worth considering a little bit the chronology of these various rules. Rule 11 was enacted about 50 years ago when the current disciplinary system and the current court system was created. And that absolute immunity sentence is in it was section 9 in those days, but is in that rule as it was originally enacted. Second sentence is different, because it doesn't discuss at all.
Mr. Fox, I'm sorry to interrupt, but the argument in your brief from statutory interpretation and now your argument from the history of the evolution of the rule is, I understand it, although I can't say I know where you were going with all of that, but how is a practitioner who is not versed in the history that you're spinning out here, how are they to know? Wouldn't you concede the rule has some lack of clarity to it? After all, the title of the rule is immunity. Regardless of what the history may say and parsing the first sentence against the second sentence, would you say that someone reading this rule in good faith could think that they do have immunity in the disciplinary process for filing a complaint? Is it possible that's a good faith, reasonable, even if mistaken reading of the rule?
I think I'm going to disagree with you, but you may be right and I may be wrong. I think actually the heading of the rule is miscellaneous, but I will agree with you that
I'll say the first word of 19A is immunity.
no,
Period.
but I think that's important. And here's the reason why. I would think that any lawyer would realize that disclosures that a client made to the lawyer in confidence, or secrets of that client which were embarrassing or, as Mr. Paul would contend, potentially criminal, have to be maintained in confidence, except in the most extraordinary circumstances. And any lawyer who was going to resort to the disclosure of client confidences and secrets would, I think, have to find something in the rules that justified his doing so. And the first place that you would look, I would think, would be Rule 1.6, because that's the rule that governs client confidence and secrets. And the exceptions to 1.6, E3, I think is the relevant one here, say that you can only make those disclosures in the context of disciplinary proceeding when it is necessary to your defense, and you must make those disclosures in as limited a fashion as possible.
So, Mr. Fox, that's where I am going to interrupt. I understand that the information that was disclosed in what was labeled a complaint. Had it been labeled a response to the disciplinary complaint, would ODC have charged a 1.6 violation?
Yes, because let's get the chronology straight. We had a complaint filed by the client in April, and Mr. Paul's defensive response to that was done in May. 3 months later, he filed a complaint against her, which he labeled as a new complaint. And in that complaint, he not only addressed the lawsuit out of which this complaint, the client's complaint arose, was a lawsuit in which Mr. Paul was representing her in Prince George's County. There was a complete separate and earlier lawsuit in Anne Arundel County. That was not the subject of the complaint whatsoever. And so I think the simplest way to look at this is you go to that August new complaint that Mr. Paul filed, and he starts discussing her conduct in the lawsuit that was filed in Anne Arundel County, not the one that was.
Mr. Fox, with all due respect, I don't think you're directly answering Ms. Pittman's question, which is, regardless of where the information came from the earlier lawsuit or the current lawsuit, right? And I assume you're referring to that settlement agreement. If that same information was presented in Mr. Paul's response to the bar complaint against him, would there have been a violation of disclosing client confidences?
I have to disagree that I'm not answering the question. The first thing I said was yes, and I was now explaining why. And the reason is that it relates to a lawsuit that is completely different.
But doesn't that information still relate to the client's credibility, who presumably she's also leveraging by the fact that she herself is an attorney filing a bar complaint against another attorney? Doesn't that, even if it's from a prior lawsuit, it's still information, I would think, that your office would take into account in evaluating her credibility?
Well, I don't
Even if it's in a separate case.
No, I strongly disagree with that. Rule 1.6E does not give a lawyer the ability to say anything that he wants about his client who has filed a complaint against him, because the client's credibility is an issue, as it's going to be in very many cases, because the rule says you have to disclose what's necessary, and you have to disclose it in a limited fashion. And
So Mr. Fox, and maybe you put this in your brief, and if so, I apologize if I missed it, but are there published cases, in which an attorney has been found to have violated 1.6 because the response to the disciplinary complaint went beyond what was reasonably necessary to defend?
I don't think there's a case in the District of Columbia that addresses it either way. So I think the answer to that is no.
So wait, Mr. Fox, if let's just forget about the fact that the client was a lawyer and she is accusing Mr. Paul of misconduct and, all the sorts of things that she accused him from. And Mr. Paul discloses that in a prior instance unrelated to his representation, this client was found guilty of forging a check. Would that information be relevant to your determination as to her credibility as it relates to the complaint that she's making against Mr. Paul?
Well, now you're not talking about confidential or secret information. You're talking about public information.
I'm focused more on the credibility part, because it seems like you're parsing between whether or not it's a client confidence or not. And I understand that that's your position, and I respect that. I'm just trying to understand what your office would take as information relevant to the issue of credibility of the client accusing the lawyer of misconduct.
Well, I certainly think in any context, if a client has a criminal conviction, that's an impeachable conviction, that the lawyer could disclose that. But I think we're far afield from what is at issue in this case.
Mr. Fox, let me see if I can bring it closer to our facts here. It sounds like you're suggesting that if a lawyer intends to defend their violations by attacking the credibility of the former client, that is a bridge too far. Like you seem to be suggesting that they can defend on other matters, they can defend in other ways, but they can't defend around the credibility of the person, the client making the complaint against them. Is that what you're suggesting to us?
No, I'm not saying that the credibility is off limits. I'm saying that some information that relates to credibility may be off limits. In other words, that is too tangential, that, what we had here was an allegation, not a conviction, an allegation that Mr. Paul made about some supposed misconduct that occurred in another case, the Anne Arundel County case. I guess it went, it would go to credibility under some definition, but it's not like we have there's a finding of fact that somebody engaged in fraudulent conduct or.
Mr. Fox, sorry to interrupt you, but is your point on this piece of information that you're discussing, did it come to respondents' knowledge because the client asked him about it?
It frankly is not clear, because if you go and read the document, which is with one of the exhibits in the case, what he says that she did this conduct in another case, and then he identifies supposed witnesses who can explain the conduct and so forth. And incidentally, it's not at no time in that letter that he files in August does he link this conduct to her credibility in the context of his defense to the charges that she has made against him. He's not talking about, I mean, this letter doesn't purport on its face to be a defense to the disciplinary charges that she has raised. It purports to be a separate, as his words, new disciplinary complaint that he is making against her for additional conduct that she made. I mean, this is not.
But aren't you? But that's kind of the point here, is that, and it brings back to Ms. Pittman's original question, which was, if the same information was presented in a response to the bar complaint against him, it's your position, as I understand it, that it would have been improper for him to have raised that information because it was in a prior lawsuit and or because it disclosed client confidences, even though, as I understand it, client confidences are routinely disclosed in defense of bar complaints. Am I incorrect about that, Mr. Fox?
No, certainly that's one of the waivers that a client can make, but it's not a universal waiver. It's got to be relevant. It's got to be necessary to the defense, and the disclosure had to be limited to what's necessary. And it would be my contention that was not the case. But really, it wasn't raised in that context.
Altering a settlement agreement is not relevant to your determination as to the client's credibility. If it's true, right? And he's an officer of the court as well. He's making a bar complaint against another bar, a member of the bar. If that's true, that would not at all be relevant to your inquiry?
Yeah, I can't say it would not be relevant, but look, if we were in a court and I was trying to impeach a witness with some prior conduct, the court would make some determination, not just of relevance, but whether it was a sufficient impeachable, I don't know, I'm not sure what the noun is, but that this prejudicial information could be introduced. But really, we're down another track here, because he did not introduce that information in that context. That's not what he did. I mean, if he put it in his first letter,
on the sort of procedural aspects of it, that he asserted a new complaint. But I let me just raise one more question about this. Was there ever a determination as to whether or not his bar complaint against his former client, was that found to be frivolous? I understand there wasn't a finding against her, but was it found to be a frivolous complaint, like that had no merit whatsoever?
Well, we dismissed it with a contact member's approval. That's not the standard that we apply when we evaluate the complaints. We look at the complaints to see whether there's a possibility of clear and convincing evidence of a violation of the disciplinary rules, and under that standard, we dismiss the complaint. Now, there's no finding. There's never a finding in that context that something is frivolous.
Mr. Fox, if I can interrupt you, I want to go back to your initial assertion that the immunity conferred by Rule 19A is limited to immunity from civil suit. And I want to talk a little bit about the Spikes, the Court of Appeals in the Spikes case, who explained that the policy interest underlying the immunity of 19A is to encourage individuals to come forward with ethical complaints without the fear of reprisal. And in Spikes, they rejected the argument that we shouldn't be immunizing people to use the disciplinary system to make baseless accusation and harm the professional reputation of attorneys. And the court pointed out that such an argument overlooks that the rules also provide confidentiality for initial complaints to bar counsel. And so I'm trying to understand why a limitation of immunity from civil suit, how to square that with the policy rationale that the court explained in Spikes.
Well, I will respond. I do really want to get back to my chronological point at some point, but let me respond directly to what you're saying. As I read that statement in Spikes, it's an explanation as to why the policy of encouraging people to make disciplinary complaints by affording them immunity is not that harmful to the lawyers, because the first sentence says this is our policy. Second sentence says it's not that harmful to lawyers because it's a confidential process. You know, so if the complaint is frivolous, it never goes anywhere. And one could make that argument, and this is a good way to segue back into where I was going, chronology, I think. One could make that argument in the context of this case, in the sense that N.E. was a lawyer, and that if Mr. Paul made a non-meritorious complaint, which he did, against her, it wouldn't go any further than the confidential process. But what one would have to square that with is the existence of Rule 1.6E 3 and Rule 8.4G. And this is my chronology position. Those both of those rules are part of the rules of professional conduct enacted in 1990, effective January 1, 1991. How many years is that? 20 some years, 18 years after Rule 11 and the wording of absolute immunity was adopted. And so the court, the same body who wrote Rule 11, when they go from the old code, maybe nobody but me is old enough to even remember that, but up until the 1991, we had this old code on all these DRs and ethical considerations. The court went to a completely new system, adopted a new set of rules, and in those rules was 8.4G, which says that it's unethical for a lawyer to file to make a disciplinary charge solely for the purpose of obtaining advantage in a civil case, which we're not saying is what happened here. But the point is that they said that under some circumstances, it was unethical and a violation of Rule 8.4G to do what Mr. Paul did. Obviously, that means there's no absolute immunity in the context of the disciplinary system for a lawyer who makes a disciplinary complaint against another lawyer. Because if that lawyer does so solely for the purpose of obtaining advantage in a civil suit, he's violated 8.4G. And the court adopted that rule years after it adopted rule, it wrote Rule 11 and put that into effect. Similarly, and there in the old DRs, there was a provision that said it wasn't nearly as specific as Rule 1.6. It said that a lawyer could make limited disclosures when it's necessary to defend himself. It didn't talk about disciplinary complaints or specifically. It said that in general. 20 years later, or when the new rules are enacted, the court says you can make those disclosures only to the limited extent necessary. Now, the implication of that is that if a lawyer, as we contend on our hypothetical that Ms. Pittman got put to me, that, you know, if we contend on that hypothetical that in response to a disciplinary complaint, a lawyer made disclosures of client confidence of secrets that were not necessary and that were not limited, then that person could be prosecuted, presumably. I mean, otherwise, that violation of the rule is unprosecutable. And so I think Mr. Hora was, the implication of Mr. Hora's question that this was necessary for the credibility, because it went to credibility, is wrong. And if I'm right about that, if the absolute immunity is interpreted the way Mr. Paul suggests it should be interpreted, then you couldn't prosecute a person for that. And it doesn't seem to me that the same court that created Rule 11 would have adopted later disciplinary rules, which clearly make it unethical in some circumstances for lawyers to say certain things in disciplinary proceedings and not be able to prosecute that person. Doesn't make any sense. It's not a way of construing the rules that makes any sense at all.
So, Mr. Fox, I'm aware that you can't see the clock, so I'm going to say that you are out of time.
Okay.
But Ms. Sargent has a question, and I also was curious after Ms. Sargent's question, do you want to address anything on 8.4? But we'll start with Ms. Sargent.
Yeah, Mr. Fox, sorry, you're out of time, but I really want to ask you, why did you consider taking an exception to the decision by the hearing committee not to impose a fitness requirement? And if so, why is that?
Well, I considered it, of course, but I generally, if you look at the what the hearing committee says about that, they sort of ground it in their factual findings. And I generally am reluctant to, because I frequently want to support hearing committees' factual findings, I'm generally reluctant to take exceptions when the hearing committee has made its determination based on factual findings. Now, I recognize that sanction is not a purely factual thing, and that I could have made that argument, but just I made the call not to take that exception.
Okay, do you want anything on it? I can give you 1 minute for 8.4 if you have anything.
I was not going to address 8.4
Okay.
unless there were any specific questions about it.
Okay. We can return to Mr. Paul and his rebuttal. Mr. Paul, as you can see, I'm somewhat flexible with time. So, we'll give you some time on the clock.
Thank you, but I won't need it. First, just to rebut all of Mr. Fox's long, lengthy legislative history. A subpart of the legislative rule, the literal rule, is you don't consider legislative history when the rule is unambiguous. The Spice Court has already held that this rule is unambiguous. It's got an absolute privilege attached to it. That's the only way people will come forward with complaints to the grievance if they think they're going to be reprisals. And I can tell you, I read this rule before I filed this grievance. Contrary to what the petitioner's argument in the hearing commission says, I considered a lot of things before I filed this grievance because I didn't want to be bothered by this person anymore. I wanted out of this, but I was stuck in it, so that's why I filed the grievance. I forgot what I was going to say then. Sorry. I'll
That's okay. Take a moment.
I'll move on to something else. To go on to
Mr. Paul, Mr. Paul, let me ask you this question maybe. Did you think that you needed to file the complaint in order to mount your defense? So in other words, did you think you had to file the complaint to mount your defense and you just couldn't mount your defense by responding to the allegations?
Yes, to some degree. I believe the complaint and the new complaint are interrelated because I believe I'm dealing with a petitioner, Office of Disciplinary Counsel. I thought it was all related. I didn't think there was a different file. I filed a new complaint because I believed I would have absolute immunity by filing a new complaint. I wasn't sure whether I would have absolute immunity by filing a defense. I thought all my disclosures were protected by my reasonable defense argument, but I wasn't sure. But I was pretty sure by that Rule 19, by filing a complaint, that I had absolute immunity. And let's consider due process here, the notice argument. A person has to have notice of what the content is prohibited. I mean, I've seen several people ask questions. Well, how will a lawyer know what is prohibited? This rule is not, doesn't limit it to just civil suits or administrative proceedings. It says any suit. And this is a suit by any stretch of the word. To take Ms. Priam's argument just one step further, Spice Court wrote that false and misleading grievances can be filed against attorneys, and there's still immunity for the complainant. So if the complainant has immunity for filing false grievances, false and malicious grievances, like John Doe did in this case, and the person also happens to be an attorney, like John Doe is in this case, then that person still has immunity, because filing false and malicious grievances, filing false and malicious pleadings is prohibited by the disciplinary rules. You couldn't charge them because they filed a complaint. And the same thing goes here. One point,
Because there are two types of people who can file bar complaints. There are lawyers and there are non-lawyers. Are you making the argument that lawyers who are otherwise subject to the rules of responsibility can file anything in a bar complaint and not be held to any other rules of professional responsibility?
I wouldn't go that far. I would say as long as the, I'm sorry, rephrase the question, ask me the question one more time so I make sure I understand it.
For your immunity argument, there
Yes.
are non-lawyers, but there
Right.
are also lawyers, and this case is one of them, who is filing a bar complaint. And if I'm trying to see if I'm taking your argument to its logical conclusion, you're saying that an attorney who files a bar complaint can do so without regard to compliance with any other rules of professional responsibility, because
Yes,
they're absolutely immunized.
yes,
That's your argument.
yes.
Okay, thank you.
And I believe that what I just said proves that. If an attorney files a false pleading, they'd be charged. Not going to be charged in this case. John Doe's not going to be charged in this case. She has immunity, just like I should have immunity. I don't know if I said this already. Oh, yes, I did. Lastly, I guess my credibility is on the line here. So I guess that's part of this hearing. So I honestly believe that all the disclosures I made were reasonably necessary for my defense. This person, you have the complaint she filed. That was a serious complaint. If you've read all those pleadings she filed, it's very serious. There's a lot of allegations in there. I didn't take this complaint lightly. I took it very serious. So I dropped a nuclear bomb, if you want to say that. But I wanted to be found not guilty of these charges, and I was found not guilty in Maryland. And to take Mr. Fox's statement about the complaint being dismissed by by the petitioner about John Doe's complaint, it was dismissed with a little note in there that some of the statements that she made could not be attributed to just a lack of procedural knowledge. So what the person who wrote that letter was saying was some of those statements she made were false. That's in that letter that I don't know if that's part of the record, but that's the letter when they dismissed her complaint. Thank you. I apologize for meeting you this way.
We thank both of you for your argument. The case is submitted and you may exit our virtual courtroom.